and then there's a breach of that warranty, then what does the other party do? What remedy does he have in case there's a breach of that warranty? Does he go to the court, or does he get an indemnity in the contract? So these are vital elements. Again, what I'm really suggesting here is that you try to link up your study of the contract law as what you have studied in your college by your professors, and try to relate it to a draft contract, which is a practical side of the uh, contract understanding, where you get into a practical discussion and practical uh, um, implementation of what you necessarily study in your college, and then try to relate it to the clauses in the draft contract. So warranties, guarantees, and um meeting up to those warranties, guarantees, the promises is very, 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 very key in a draft contract. Similarly, would be indemnities, and you would have studied indemnities in detail in your contract law classes, and your professors would be, I think, very, very insistent that you know and understand the theory on indemnities, and you would have had full fledged lectures on what is an indemnity, and what actually comprises an indemnity and guarantee. But when you look at a draft contract and say a practical implementation of an indemnity, whether that indemnity should cover you from all losses, or whether it should be only for a claim by a third party. What is a claim? What is a loss? What can comprise a loss? Is something that probably you need to do more study in detail, and try to understand as what could comprise a loss for which the party would be entitled to be indemnified or compensated for the loss. Uh, and what are the grounds on which the indemnity is entitled to? Uh, Whether you are entitled to get an indemnity for just a breach of the contract, or there are some specific grounds on which you should be entitled to be indemnified. And what are those specific grounds? I mean, unless and until there's a clear cut understanding of the business, and what is the nature of the business, what is exactly a part of the scope of the contract, is very difficult to draft an indemnity clause, and that would require a full-fledged session on drafting and understanding an indemnity section. Then, what I would stress on is also having a clear understanding of the party's liabilities, just as it is important to know the rights and obligations. It is important to also know what are the rights, what are the liabilities of the parties, and what happens in case there's a breach of the contract, or there's a failure to meet the obligations, or there's a non-performance issues, or there's a material issue related to not meeting up to the terms and conditions of the contract. So for really getting a grip on the terms and conditions, it's important to know the consequences of failure to meet up to those terms and conditions, which would be the resultant liabilities, and what kind of liabilities you carry under the contract. For instance, a non-performance for some or breach of the terms and conditions would be a material liability, and that could end up as a huge loss for the company, where as part of damages they may be sued for millions of dollars, and that could result in the company getting bankrupt. For instance, a company in a particular contract may have certain obligations related to protection of data. Now, if the data obligations are that vital, say in a scenario in Europe, where if there's a breach,